Hello, this is Matt on the Moon Family Sedan channel. It looks like Judge Torres knew the SEC was wrong on key points in the SEC v. Ripple lawsuit long before Ripple's legal team addressed those issues. And this gives a strong hint as to the judge's thought process and how this lawsuit very well may end. And so I'm going to share with you perspective from XRP community member and attorney Bill Morgan on this very topic because I appreciate his insight. We are so fortunate to have so many brilliant legal minds in our XRP community because, and not that the rest of us are idiots, but if you don't have a legal background, being able to read between the lines and pick up certain cues and the way things are written from a legal perspective, you're not going to be able to do it if you're not an attorney. And so to have someone like attorney Bill Morgan break down why he thinks it seems that, it's certainly possible that Judge Torres may have been on Ripple's side, frankly, before Ripple even made some key arguments. He breaks it down right here, and I'm going to share those thoughts with you. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say are right. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So, did Judge Torres, know that the SEC was wrong a bit sooner than we thought? Well, here's what attorney Bill Morgan had to say. What is the relevance of the blue sky issue in the fair notice defense? I was thinking it was only relevant to the Howey analysis and didn't notice until now its role in the fair notice defense. But Ripple's opposition to the SEC's motion for summary judgment on the fair notice defense clearly argues that Ripple sales involve no contracts and lack the essential ingredients that define the term investment contract. And then he shared this little screen grab, and the relevant portion is in yellow and on your screen. It reads as follows. Defendants' transfers of XRP often involved no contracts in the first place and never involved the essential ingredients that define the legal term investment contract, so no person of ordinary intelligence would think they were investment contracts. And then attorney Morgan says, so no person of ordinary intelligence would think those Ripple sales were investment contracts. Those essential ingredients, as identified by Ripple in its summary judgment opposition brief, include post-sale obligations to investors or rights against the seller, as the Howey investors had. And then they shared this screen grab, and the relevant portion in yellow here, you can see, nor does this case involve contracts, at least in large part, post-sale obligations, or rights as against the seller. And so, folks, it's obviously already right there, markedly different than what happened in the SEC v. W.J. Howey Co. case back in 1946 with the Supreme Court ruling. Obviously. And that's why, it's also, by the way, why I'm very optimistic that justice shall be done. Even if we get a piss poor ruling from Judge Torres, which is not what I think is going to happen, but even if we do, if this thing actually makes it to the Supreme Court, the SEC is going to get bitch smacked on down. Going to knock them bitches back into last Tuesday. Attorney Morgan continues, I think Judge Torres was right on top of this issue early in this matter, well before the blue sky issue was articulated by Ripple in its summary judgment motion. So check this out, folks. And this is where we're getting to some of the meat of this. Just to summarize this issue, Ripple argues that there must be a contract between the seller and investors even if the scheme goes beyond the contract. It argues it owes no post-sales obligations to XRP holders who have no legal rights against it. Now, Judge Torres, when she made her decision dismissing the SEC's motion to strike out the fair notice defense, found as relevant Ripple's assertion it had no relationship with the vast majority of XRP holders. So this is key. Check this out. The relevant portion reads as follows. It also asserts that it has not sold XRP as an investment and that it has no relationship with the vast majority of XRP holders. Well, that's something. Again, do you see the relevance of the tie here? Because again, just let me read it one more time to make sure that's properly sinking in. Attorney Morgan wrote, Judge Torres, when she made her decision dismissing the SEC's motion to strike out the fair notice defense, because again, the SEC, they wanted the fair notice defense out of there, found as relevant Ripple's assertion it had no relationship with the vast majority of XRP holders. So that is the judge acknowledging that Ripple has no relationship, period, full stop, with the vast majority of XRP holders. Now, the relevance of that is substantial. So check this out. Attorney Morgan continues. Now, no relationship with XRP holders is broadly expressed, but I suggest that what the judge contemplated here was no contractual relationship and anticipated and understood where Ripple was going with the investment contract argument and its relevance to the fair notice defense. So folks, do you see the key part right there? And I'm glad that he's breaking it down like this, because I haven't seen an attorney come at it with this perspective, but it makes all the logical and rational sense in the world. Again, Ripple stating obviously didn't have a relationship with the majority of XRP holders, and that's true almost 0% of them, because there are so many of us. There's millions and millions and millions of, almost 0%. And so Attorney Morgan is saying what might have been going through the mind here. And if that's what's going through her mind before Ripple even made the argument, you know, that there would be, because again, the theory being here from Attorney Morgan is, what if she's thinking that means there's no contractual relationship? Because if there's no contractual relationship, no post-sale obligations, all that stuff, well, then the SEC is flatly, blatantly wrong. So that would be substantial. If that's what's going through her mind, that gives us a hint as to how she may be ruling when this all drops on down, which we may have any day. I don't know if it's going to come down this month or not, but it could. And then Attorney Morgan continues, and he says, so let me just read the last sentence so we can get the flow going again properly. He said, now, no relationship with XRP holders is broadly expressed, but I suggest that what the judge contemplated here was no contractual relationship and anticipated and understood where Ripple was going with the no investment contract argument and its relevance to the fair notice defense. And it must be relevant. The judge in that decision on the motion to strike out the SEC's fair notice defense specifically expressed the principle that requires fair notice be given as a clarity requirement. And then he shared this little screen grab where it points that out. And then he continues. Attorney Morgan says, I would not be surprised if Gensler's incessant claims that there is clarity and all altcoins are securities are a reaction to this decision. No earlier crypto case before the commencement of SEC v. Ripple involves sales between the seller and buyer in which factually there was an absence of a contract with post-sale obligations or rights of holders of the token against the seller. If Ripple is correct in law on the blue sky issue, then no prior crypto case or guidance of the SEC contradicted this position. How did the SEC satisfy the clarity requirement? There is considerable evidence it did not give clarity and did not regard XRP as a security. Getting back to Judge Torres, her treatment of the SEC's Daubert challenge to the expert evidence of Alan Schwartz shows her further grasp of the issue Ripple has enlivened about post-sale obligations and its relevance to the fair notice defense. Yeah, and so I'll pause note, there are a lot of attorneys that just don't think, for one reason or another, that on the district court level, which is where we're at right now, you're going to have a judge that's going to look at the fact, the certain circumstances regarding the lack of post-sale obligations, this or that, to rule in such a way that's going to be positive for Ripple here. Yet here we have indications, as highlighted by Attorney Morgan, that actually we might see just that. And then Attorney Morgan says, recall that Alan Schwartz gave opinion evidence that, unlike the Howey contracts, Ripple's contracts did not contain post-sale obligations. And he shared this screen grab, which reads as follows. He opines that the Ripple contracts, unlike the Howey contracts, do not contain provisions which commit Ripple to perform any post-sale actions that could affect the value of XRP or return profits to any person, end quote. And so this is relevant for a number of reasons, not the least of which is that as it pertains to the expert witnesses and the Daubert motions, Judge Torres threw out the most crucial assertion of the most crucial assertions from the SEC's expert witnesses, yet here you have something that plays into exactly the point that Attorney Morgan is making. The fact that, it's the indication, it's the hint that Judge Torres likely understands that post-sale obligations are of substantial legal importance, but they don't exist here. So throughout the opinions of those experts on the SEC side, but not Ripple's expert, which is pointing that out. Do you see? It's just interesting analysis. And then Bill Morgan says, the judge has permitted this evidence, and as I have explained, it is relevant to the fair notice defense. I don't think the SEC will win on the fair notice defense at summary judgment. So it's perhaps a little hint as to what Judge Torres is thinking here, and we're going to find out soon enough, but interesting perspective. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.